Hello, everybody. My name is Spencer Pollock, and I'm a cybersecurity, privacy attorney, and data breach coach with McDonald Hopkins. Brief background about myself and my group. We obviously operate a lot on both the left of boom and right of boom sides. On the left of boom side, we do a lot of the compliance work, think privacy policies, incident response plans, tabletops, vendor due diligence, M&A work, you name it, we do it. On the right of boom side, the group's done about 18,000 data breaches. I've done about 1,100. So we are fortunately or unfortunately well versed in this. Today, I want to really talk about why what you're doing beforehand impacts what happens from a cybersecurity perspective. Why what you've done beforehand impacts what happens from a litigation perspective and from a regulatory perspective. We're going to lock both the regulatory perspective and the litigation perspective in together because a lot of the same questions are asked. So what is the big thing I see when it comes across my desk? It's really what you did before, what you did during, and what you did after a data breach. So not just an incident, we're talking now a data breach. So what about the beforehand, right? And these all this goes more toward the administrative and technical safeguards. In terms of the administrative safeguards, a lot of the regulators are asking, did you have an incident response plan? Did you have a written information security policy? Did you have an access policy? Do you have an acceptable use policy, a bring your own device policy? Did you run tabletops? What sort of due diligence did you do with your vendors? This is no longer check the box. These regulators and plaintiff attorneys are asking these deep dive questions on the administrative side. And then obviously on the technical side, they really want to know, did you have MFA in place? Did you have a patching policy? Who's responsible for this? Do you have a CISO? Do you have a CIO? Who is basically the champion of the cybersecurity side? How are you implementing this? How are you keeping up with the different vulnerabilities? They literally will send long questionnaires, and plaintiff counsels in their complaints will allege that you were negligent because you didn't do these things or you didn't do enough of these things. And from the regulators, we see increased fines and penalties when you don't have these things in place. So now what about the during? So during a data breach, everybody starts looking at one, what was your response? How long did it take? And did you take all the appropriate legal actions and obligations afterwards? So we want to make sure that you're taking the proper steps to contain the threat, eradicate, and then remediate. For you all in this audience, I'm less concerned about that. It's more of a concern too with you all and everybody else in terms of the regulatory and legal obligations. So that always gets put on the back burner. But what we really need to be looking at is how long does it take you to get notifications out to individuals and regulators? And it needs to be presented as a reasonable steps. Obviously, determining if an incident is a data breach doesn't happen overnight. But it's the narrative that you give me to present to plaintiff attorneys and regulators that's so important. It's the timeline. So it's following the proper steps. It's incorporating that incident response plan and the necessary external and internal parties to walk you through this and give someone like me those necessary facts that I present to the regulators and litigation attorneys out there. Then finally, it's what you do afterwards. Regulators especially want to know what you're going to do moving forward. So what I always tell my clients is, okay, let's go back to the start. Let's have that after action report. Let's hammer the technical sides. What can we start incorporating? Did you not have sufficient EDR? Did you not have a sufficient SOC? Did you not have a good MF? Did you not have MFA in place? Did you not have a patching policy? Was there a vulnerability out there that you just sat on for a year? How do we fix that, right? And then did you have an incident response plan? Did you do due diligence? Was this a vendor breach that then caused downstream liability onto you? How do we then make this better? Because then we take all these facts, we package them together about all the things you're going to do moving forward, and then we present them to regulators. Plaintiff attorneys don't really care about that stuff. Regulators really do care. So the main takeaway from this that I hope you have is that we need to take cybersecurity seriously beyond the technical and security aspects. You really need to take the legal and compliance side seriously as well. Thanks, everybody.